In this video, we're going to delve into the employment-based green card process with USCIS, highlighting the different steps working professionals in the EB1, EB2, and EB3 have to go through when trying to get a US green card. Coming right up. Hey, it's Chuki from SojourningScholar.com, the trusted resource for international students and working professionals in the US. This video is only focused on the steps required to get an EB1, EB2, or EB3 green card. To find out the eligibility requirements of the EB1, EB2, and EB3 green cards, you can watch this video right here and could also be found in the description section below. Generally, there are 3 steps required to get an employment-based green card status. The first step is obtaining an approved labor certification from the U.S. Department of Labor. The second step is filing an I-140 petition with the United States Citizenship and Immigration Services, USCIS. And the third step is filing an I-485 petition with USCIS. With the exception of the EB1 category and the EB2 National Interest Waiver, also known as EB2 NIW, all other employment-based categories have to go through steps number 1, 2, and 3. Also, all other employment-based categories requires a U.S. employer to file a petition on behalf of the foreign national. The only exceptions are the EB1 through extraordinary ability and the EB2 National Interest Waiver. Obtaining an approved labor certification is a step that must be undertaken by a U.S. employer. An approved labor certification provided by the U.S. Department of Labor certifies to USCIS that 1. That there are no sufficient U.S. workers able, willing, qualified, and available to take up the job opportunity at the intended area of employment, and 2, that the employment of the foreign national won't adversely affect the wages and the working conditions of other similar U.S. workers. For employment-based categories such as all EB3s and some EB2s, the labor certification must be approved before moving on to the next step, which is filing an I-140 petition with USCIS. An approved labor certification from the U.S. Department of Labor comes with a validity period of 6 months, which means that an employer must file your I-140 petition within 6 months from receiving an approval of the labor certification. The I-140, also known as an immigrant petition for an alien worker, is typically filed by a U.S. employer on behalf of a foreign national. Whoever files this petition with USCIS is called the petitioner, and whoever benefits off of this petition is called the beneficiary. With the exception of the EB2 NIW and the EB1 through extraordinary ability, a foreign national cannot be both the petitioner and the beneficiary of an I-140 petition filed to USCIS. The I-485, also called the Application to Register Permanent Residence or Adjust Status, is adjudicated by USCIS only after the approval of the I-140. Now let's talk about the concept of the priority date. The priority date is the date a foreign national expresses an interest to become a permanent resident of the US through an appropriate petition. For foreign nationals in some EB2 categories and all EB3 categories that have to go through the labor certification process, your priority date will be the date the U.S. Department of Labor receives an application for a labor certification from your employer. While other employment-based categories that don't have to go through the labor certification, your priority date will be the date your I-140 petition is received by USCIS. Now, there's also a possibility of filing both an I-140 petition and an I-485 petition to USCIS. This is known as concurrent filing, and it's possible for certain foreign nationals. To find out if you're eligible for concurrent filing, you would have to check out the US visa bulletins linked in the description section below. You would also find the video linked in the description section below where I discuss how to interpret a US visa bulletin chart. Now let's talk about the general timelines for each of these steps. Starting with the labor certification step, the US Department of Labor requires a US employer to first test the labor market before they can submit an application for the labor certification. During this test of the labor market, the US employer must demonstrate to the US Department of Labor that they were not able to find any US worker who is able, willing, qualified, and available to take up the job in question under the prevailing wage set by the U.S. Department of Labor. The processing time for a labor certification could take as long as 3 months, and the time required of a U.S. employer to test the labor market could take as long as 6 months. So when combined, the timeline to obtain an approved labor certification from U.S. Department of Labor could take as long as 12 months. As for the I-140, USCIS has an option of expediting the processing time down to 15 calendar days for certain categories. Without the expedited processing, the timeline for USCIS to adjudicate an I-140 petition could take as long as 6 months. And finally, we have the I-485 petition. Now, in the case of the I-485 petition, USCIS does not provide any expedited processing. And in some cases, USCIS could take as long as 3 years to adjudicate your I-485 petition, depending on how backlogged the USCIS service centers are. Now, also keep in mind that foreign nationals whose priority dates are not current in the U.S. Visa Bulletin chart would have to wait until their dates are current to file the I-485 petition. And for certain foreign nationals, waiting for a priority date to be current in the Visa Bulletin chart could take upwards of 10 years. Foreign nationals with an approved I-485 petition who reside outside of the U.S. could go to a U.S. consulate or embassy to apply for an immigrant visa to the U.S., while foreign nationals who currently reside in the U.S. can change their status from a non-immigrant status to the green card status. So as you can see, depending on your country of birth and your employment-based category, the timeline to get a green card could take upwards of 3 years. Foreign nationals with a pending I-485 petition with USCIS may apply for a temporary work authorization, also called an employment authorization document. They may also apply for an advanced parole document that allows them to leave and enter the US while an I-485 petition is pending. I hope you found this video very informative. Comment down below if you have any questions about the employment-based green card process. Like and share the video if you got some value out of this. And if you're meeting for the first time, make sure to subscribe to the channel to catch up with more helpful content coming your way. Thank you for watching this video, and I'll see you on the next one.